Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Freddie T. Wright, decided on June 18, 2024. Canataro, J. Defendant appeals from an order of the Appellate Division upholding the denial of his Batson challenge to the people's exercise of peremptory strikes on two prospective jurors, see Batson v. Kentucky, and denying his motion to suppress the identification testimony of two witnesses. Applying our well-settled and limited standard of review, there is record support for the determinations below that the people had valid, race-neutral reasons for striking the two prospective jurors. There is likewise record support for the conclusions of the courts below that the show-up procedure used by police was not unduly suggestive. We therefore affirm. 1. On the morning of March 26, 2017, two men robbed a restaurant located on Atlantic Avenue in Queens. Upon entering the restaurant, one of the robbers, a black man wearing a red hoodie, black jacket, and a bandana over his face, approached assistant manager Sumitra Ramsey, took something wrapped in a plastic bag out of his pocket, pressed it to her neck, and told her to open the safe in the restaurant's office. Ramsey responded that she could not open the safe and, on the robber's demand, instead opened the drive-through cash register drawers and handed over their contents. While these events were taking place, the other perpetrator was standing next to another employee, Jordan Guzman. After the robbers ran out of the restaurant, Guzman called the police. Police officer Bryce Blake and his partner were on duty in a marked patrol car about a block away when they received a radio call of a robbery in progress. The officers arrived at the restaurant within 2 or 3 minutes and Officer Blake observed defendant standing in the parking lot dressed in a black jacket and red hoodie. Upon seeing the patrol car, defendant fled. Officer Blake pursued defendant on foot for several minutes, eventually observing defendant enter a home through its back entrance. The homeowner advised Blake that the individual who entered the house was in the living room. The officers entered the home, found defendant sitting on a couch in the living room, and placed him under arrest. Simultaneously, other officers were driving Guzman around the neighborhood to see if he could identify the robbers. The canvassing yielded no positive results, but twice, Guzman indicated that individuals stopped by the police were not the perpetrator. Several minutes into the ride, Guzman overheard a radio call indicating that police had apprehended someone and heard one of the officers in the car say, "I think it is the guy." Police then brought Guzman to the house where he identified defendant from his red hoodie and from the way his eyes and forehead looked above the bandana. Police also brought Ramsey to the house to make an identification. Upon arriving, Ramsey saw defendant step out of a police vehicle with his hands behind his back and identified him as the man who robbed her based on his clothing, height, and body weight. At the suppression hearing, which took place over a year later, Guzman was able to identify defendant but Ramsey was not. Defendant moved to suppress the identification testimony, arguing that the identification procedures were unduly suggestive. The court denied the motion, finding that the identifications were not overly suggestive and improper because they were made in a very short spatial and temporal time between the incident and arrest. Additionally, the court found that the radio communication and comment overheard by Guzman while riding with police were not so suggestive as to warrant suppression of his identification. During jury selection, defendant raised a Batson challenge, as relevant here, to the people's use of peremptory strikes on two prospective jurors CC and KCCC, who was a member of the first voir dire panel, was an unmarried black man with no children who rented his home. When the court inquired of the panel if they knew anyone who had been the victim of a crime, CC responded by relating an event 15 years prior in which his cousin was arrested by police for marijuana possession at a family gathering. CC recounted that police came to the house. "They just arrested my cousin and took him out and took the other cousins. I had 2 or 3 cousins in the house at the time. So they took all 3 of them and actually, my aunt, which is their mother, with them to the precinct. So they just raided the house and took them all out." Notably, when asked whether they were all arrested in that incident, defendant answered yeah. CC gave assurances that he could be fair notwithstanding this incident, but, later, when the people inquired whether he harbored any negative feelings about the police as a result of this incident, CC responded, "Well, yeah, just the fact that they took everybody. I didn't know that they had to take everybody. But that was it." Defendant challenged the people's strike of CC on the ground that it was an attempt to improperly exclude black jurors. The court found that defendant had made a prima facie showing that the people sought to exclude CC on the basis of race and asked them to provide a non-discriminatory reason for the use of the strike. The people responded that CC had cousins who had been arrested, had other friends that had been involved in multiple arrests, that he rents, and he has no children, and is not married. Defendant countered that there were jurors that are on this panel that are not African American who meet every one of those criteria that was just enunciated. Supreme Court found that the reasons proffered by the people for their strike of CC were not pretextual. Casey, a black woman, was another prospective juror who was interviewed during the third round of jury selection. Casey answered affirmatively when the court asked if any of the jurors worked in law enforcement and explained that she worked for the Department of Probation and Family Court. Specifically, Casey stated that her job entailed interviewing juveniles who had been charged with a crime to determine if they should receive intake diversion, which is, like, a short-term probation, or if they go to see the judge. The people struck Casey from the panel with a peremptory strike. Defendant challenged the use of this peremptory strike on the ground that the people were improperly excluding Casey based on race. The court found that defendant made a prima facie showing of discrimination and required the people to give a race-neutral explanation for their strike. In response, the people noted that Casey works for the Department of Probation in the Family Court, which is obviously within the legal field. And on top of it, she works for probation with juveniles, and that, because of her job, sympathy might come into play. Defendant countered that Casey had made clear that she wouldn't allow sympathy to interfere in her deliberations and that there have been other people with law enforcement backgrounds that have not been challenged by the prosecution. Supreme Court found that the reasons proffered by the prosecution were non-pretextual and denied defendant's Batson challenge. A jury ultimately convicted defendant of second-degree robbery and second-degree criminal trespass. The appellate division affirmed, holding that defendant had failed to satisfy his burden of demonstrating, under the third prong of the Batson test, that the facially race-neutral explanation given by the prosecutor was a pretext for racial discrimination. A judge of this court granted defendant leave to appeal, and we now affirm. 2. The legislature has long afforded parties to a criminal trial a statutory right to exercise a certain number of peremptory strikes, which are objections to a prospective juror for which no reason need be assigned, CPL 270.25, 1. Unlike a strike for cause, a party exercising a peremptory strike need not give a specific reason why they believe a juror cannot be impartial, see People v. Allen. Nonetheless, equal justice under the law requires that a criminal trial be devoid of racial discrimination in jury selection, and the Batson process endeavors to ensure that such discrimination does not infect the selection process, see Batson. A Batson challenge requires a three-step analysis to determine whether a peremptory strike was used for the purpose of improper discrimination. At step 1, the moving party must make a prima facie showing that the opposing party has exercised a peremptory strike to remove a potential juror on the basis of race. At step 2, the burden shifts to the non-moving party to come forward with a non-discriminatory reason for each of the challenged strikes, see People v. James. Finally, at step 3, once race-neutral reasons for the strike are provided, the inference of discrimination is overcome and the ultimate burden shifts back to the moving party to persuade the court that the reasons are merely a pretext for intentional discrimination, People v. Smokum, see People v. Hecker. A trial court's determination at step 3 of the Batson analysis as to whether use of a peremptory strike is pretextual is accorded great deference on appeal, Hecker. A trial court is best situated to evaluate both the words and the demeanor of jurors who are peremptorily challenged, as well as the credibility of the prosecutor who exercised those strikes, Davis v. Ayala. Even where reasonable minds might differ as to whether a proffered justification is pretextual, the trial court's finding should be affirmed so long as there exists record support for it, see People v. Hernandez. Only where a trial court's decision as to pretext finds no support in the record may that decision be overturned on the cold record of appeal, see People v. Malloy, Hecker. The people's asserted reason for striking CC was that he had cousins who had been arrested, had other friends that had been involved in multiple arrests, that he rents, and he has no children, and is not married. Initially, we have characterized family involvement with police officers as a clearly non-pretextual reason for exercising a peremptory challenge, Smokum. Moreover, here, the record demonstrates that CC felt strongly about the prior incident in which his cousin and family members had been arrested. Indeed, CC first mentioned the arrest in response to the court's inquiry as to whether any of the potential jurors knew anyone who had been a victim of a crime, not in response to an inquiry about whether jurors knew anyone who had been arrested. Further, CC stated that police raided the house and barged in prior to arresting his cousin and detaining other family members, suggesting that he harbored strong feelings about the methods used by law enforcement. Finally, CC responded in the affirmative when pressed by the people as to whether this incident caused him to have negative feelings towards police. Any one of these responses would constitute record support for the trial court's pretext determination. Overall, CC's responses gave rise to a reasonable inference that, 1. He viewed the arrest of his cousin for marijuana possession as a crime against his cousin. 2. He viewed the arrest of his cousin as a raid by police, and 3. His negative feelings towards police could affect his view of police witnesses in the case, regardless of any contradictory assurances he might have given. These inferences are patently reasonable, and the trial court's determination that the non-discriminatory reasons offered by the people in support of their peremptory strike of CC were credible and non-pretextual finds ample support in the record. See Miller v. Cockrell. See also Smokum. While it is true that unequal application of even facially neutral reasons for a strike can support a finding of pretext, that is but one factor for a court to consider and does not demonstrate discriminatory intent in and of itself, especially where the circumstances surrounding the challenged juror are distinguishable. See Flowers v. Mississippi. Here, although there were other prospective jurors whose family members had also been arrested, the record does not indicate that those jurors shared CC's feelings about the police or felt as strongly as he did about their respective incidents. None of those other jurors made comments indicating that they felt the arrest in question was wrong, or that they had lingering negative feelings about it. Similarly, although the dissent is correct that disparate questioning can arm a prosecutor with seemingly race-neutral reasons to strike the prospective jurors of a particular race while declining to seek what they do not want to find about white prospective jurors, quoting Flowers, this observation lends more towards a condemnation of the Batson process itself than it does the trial court's decision in this case. After all, Batson requires simply that the people provide a credible non-pretextual reason for striking a particular juror. It does not require a justification for why other jurors were not stricken, and the Supreme Court has never endorsed such an analysis. Moreover, the prosecutor here did question other jurors who related negative experiences with police. For instance, KL revealed during voir dire that he had a bad experience with the police approximately 10 years earlier when they detained his mother while verifying that she had a vendor's license for her food truck. The prosecutor questioned KL about his lingering negative feelings toward police officers because of this encounter and, ultimately, challenged KL for cause. Further, the people were not required to credit CC's statement that his feelings regarding his cousin's arrest would not influence his ability to be fair and impartial if his other answers showed an inability to live up to that promise. See Hernandez. The dissent's emphasis on CC's self-proclaimed impartiality seems to ignore the purpose of peremptory challenges, which exist for precisely this kind of situation. Indeed, had CC answered the other way that he would not be able to be fair and impartial, the people would have had a legitimate basis to challenge CC for cause. CCPL 270.20, 1. On this record, we cannot say as a matter of law that the people's proffered reasons were pretext for race-based discrimination, Malloy, quoting Hernandez v. New York. In so concluding, we do not supply our own non-pretextual reasons to justify the people's peremptory strike. We merely review the record before us as is our obligation and find ample support for the trial court's undisturbed factual finding that the people's treatment of CC, to the extent it differed from that of other jurors who had relatives arrested, was not racially motivated. See Hecker, People v. Vanover. Unlike the dissent, we cannot engage in de novo fact-finding. Finally, the only Batson issue before us on this appeal is whether the record supports the trial court's determination at Step 3 that the people's stated justifications for striking CC and KC were non-pretextual. We note, however, that the trial court did articulate the wrong test at Step 1 of defendant's Batson challenge relating to CC, stating that the defendant had met his burden of showing that the people were excluding jurors solely on the basis of race. However, the dissent's attempt to arrogate this misstatement into reversible error on an issue that was neither objected to below nor raised by defendant on appeal is misplaced. The parties agree that the trial court properly concluded that defendant satisfied Step 1 of the Batson analysis. There is no evidence that the court's misstatement at Step 1 infected the court's Step 3 analysis. The court applied the correct standard at Step 3 in determining that the people's proffered reason was not pretextual, finding no basis for discrimination in the way the people exercised their strikes, and that it believed the reasons given for these jurors given peremptory challenges were not pretextual and were the genuine reasons why the prosecutor challenged these jurors. The court's function at Step 3 is distinct from its role at Step 1 and, the dissent's transference theory notwithstanding, the trial court here did not reject defendant's Batson challenge on the ground that defendant had failed to demonstrate that racial discrimination was the sole basis for the strikes. Given the court applied the correct standard at Step 3, any mischaracterization of the standard at Step 1 is not determinative. As for prospective juror KC, the people offered a race-neutral reason for their use of a peremptory strike, specifically that she works for probation with juveniles. The people expressed concern that KC's job duties would cause her to be inappropriately sympathetic to defendant. Casey's job involved determining whether juvenile offenders would be entitled to intake diversion, or face prosecution, and she was previously employed as a caseworker. We have previously recognized that a party may permissibly strike a juror who works in a certain field, because that party believes for reasons unrelated to the facts of the case that such individual may have a more sympathetic attitude or view toward the opposing party. Hecker, citing People v. Wilson, permissible for the people to challenge a social worker on the basis they may be predisposed to sympathy towards defendants. See also People v. Hardy, use of a peremptory strike against a juror who was an aspiring social worker. People v. Wint, use of peremptory strikes against psychiatric worker and social worker. People v. Mancini, use of a peremptory strike against a teacher. Here, we cannot say that there is no record support for the trial court's finding that the reason offered by the people was not pretextual, and as such there is no basis for reversal on these grounds. See Hecker. 3. Finally, the courts below did not err in holding that the show-up identification procedures used immediately after defendant's arrest were not unduly suggestive. Show-ups are generally suspect and disfavored. People v. Deuven. Nonetheless, at the crime scene civilian show-up identifications are not presumptively infirm and are permissible if exigent circumstances require immediate identification, or if the suspects are captured at or near the crime scene and can be viewed by the witness immediately. People v. Riley. See People v. Johnson, People v. Guilford. Although this court has stated that a show-up procedure in which a suspect is handcuffed and in the presence of police is suggestive and not preferred and presses judicial tolerance to its limits, People v. Deuven, we have concluded that such a show-up is reasonable under the circumstances when it is conducted in close geographic and temporal proximity to the crime. People v. Briscoe. When a show-up is done as part of one unbroken chain of events, crime, escape, pursuit, apprehension and identification, such a procedure is acceptable. Deuven. See also People v. Ortiz, proof that the show-up was conducted in close geographic and temporal proximity to the crime will generally satisfy the people's burden of showing that a show-up procedure was not unduly suggestive. As we have recognized, prompt show-up identifications by witnesses following a defendant's arrest at or near the crime scene have been generally allowed. People v. Johnson, quoting Deuven, accord People v. Howard. Moreover, whether a crime scene show-up is unduly suggestive is a mixed question of law and fact. Thus, if record evidence supports the determination below, this court's review is at an end. Briscoe, see People v. Romero, Howard, Guilford, People v. Clark. Here, as the trial court found, the show-ups were conducted within a few blocks of the crime scene and took place immediately after the robbery and defendant's apprehension. That defendant was handcuffed and in the presence of police officers is not unusual for a crime scene show-up justified by exigency, particularly where a weapon may have been used in the crime. See for example Howard, Guilford. Given that the police were looking for armed robbers, they logically would have wanted to move as quickly as possible to find out whether they had apprehended the perpetrator, and a show-up is not improper merely because the police already have probable cause to detain a suspect. Howard. That the police may have had cause to arrest defendant for trespass, as the dissent contends, does little to mitigate the concern that, if he was not identified by the victims as one of the robbers, the perpetrators of that crime might have remained at large in the community. Moreover, there are indicia of reasonableness in the procedures used. Defendant was not shown handcuffed in the back of a police car. Compare Deuven, he was not shown to the witnesses with any evidence of the stolen property. Compare Riley, and the show-ups were conducted separately, reducing any risk of the witnesses inadvertently influencing each other. Compare People v. Adams. To the extent defendant argues that statements overheard by Guzman in the back of the police car were unduly suggestive, certainly, such conduct is not to be encouraged. Nonetheless, it is pertinent that the police had already shown Guzman two other individuals who they presumably also suspected could have been the robbers, and Guzman declined to identify as the perpetrators. In any event, even if it is possible to disagree with the lower courts here, it simply cannot be said that no record support exists for their unanimous determination that these show-ups were reasonable and not unduly suggestive. Howard. As a result, the determination of the hearing court in this case, undisturbed by the appellate division and supported by evidence in the record, is beyond our further review. Guilford. Accordingly, the order of the appellate division should be affirmed. Order affirmed. Opinion by Judge Canataro. Judges Garcia, Singas and Pritzker concur. Chief Judge Wilson dissents in an opinion, in which Judges Rivera and Troutman concur. Judge Halligan took no part. Decided June 18, 2024.
Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law